Welcome to the General Data Protection Regulation GDPR online course. Finally, Lesson 3 continues by exploring personal health data, medical privacy, and the concept of medical confidentiality. The lesson objectives are understanding the legality of processing personal health data and medical confidentiality, and analyzing the content of medical records and right of access. This lesson will help you to develop a strong sense of responsibility for ethical data handling and privacy protection, communicate effectively with patients about the use of their data, enhancing transparency. The medical record and right of access. According to Article 14 of the CID, the doctor is obliged to keep a medical record in electronic or non-electronic form, which includes information on the patient's illness or health and personal data, name, address, etc. Paragraph 6 stipulates that the doctor shall keep the professional records in such a way as to ensure medical confidentiality and the protection of personal data. A filing system is defined in the regulation as any structured set of personal data which is accessible according to the specific criteria, whether this set is centralized, decentralized, or distributed on a functional or geographic basis. In the case of unlawful processing of health data by a medical practitioner, the protection afforded under the medical confidentiality of the CPC is broader, as it concerns any information that comes to the knowledge of the medical practitioner. If the doctor fails to establish such a relationship, moreover, they will not be able to have accurate information about the patient's health and will probably be led to an invalid diagnosis and inappropriate treatment. In addition to confidentiality, privacy and data protection are also important. They bind health professionals not only by oath but also by law. In this context, medical confidentiality, privacy, and data protection have the same purpose: to foster an environment of confidentiality. The regulation refers to health data as health-related data and is that which relates to the physical or mental health of an individual, including the provision of health care services, and which discloses information about the state of health of the individual. Crucial, therefore, for the definition of health-related data is what is considered as health. Personal health data and medical privacy. Apart from Regulation 2016/679, GDPR personal health data is protected by other legal texts such as the Regulation on Medical Ethics, both at the national level within the member states and at the European level. The protection of personal health data is a narrower concept than the doctor's duty of confidentiality for two reasons. A. Because medical confidentiality concerns any information that a doctor may know during their medical practice, and B. Because this obligation of a medical practitioner to maintain confidentiality extends to beyond the death of the patient. The concept of medical confidentiality. The concept of medical confidentiality has an ethical dimension which has three aspects. A. The right of the individual to the protection of their life. B. The relationship of trust between doctor and patient. And C. Confidentiality. Personal health data and medical privacy. In particular, medical confidentiality covers a wide range of information related to the privacy sphere of the individual and therefore may not concern purely medical information. The new Regulation 2016/679 introduces the innovation of including within the scope of protection of the special categories or personal data other types of personal data such as genetic and biometric data, some information on the sexual orientation of the data subject, etc. which was not the case under the previous regulations' institutional framework. For this reason, medical confidentiality prohibits healthcare professionals from disclosing information about patients. This is an old obligation dating back to ancient Greece and the Hippocratic Oath, which made the healing and well-being of the patient the highest goal and is of paramount importance to foster a climate of trust among patients. The concept of medical confidentiality. To ensure strict and effective observance of medical confidentiality, the doctor must a. Exercise the necessary supervision over assistants, associates, or other persons who cooperate or participate or support him in any way in their performance of their duties, and b. Take all measures to preserve confidentiality for the time after the cessation or termination of his duties. The lifting of medical confidentiality is allowed when 1. The doctor is acting in the performance of a legal duty, such as in cases of birth, death, infectious diseases, and others by general law. 2. The physician seeks to safeguard a legitimate or otherwise justified substantial public interest or an interest of the physician or of another which cannot otherwise be safeguarded. 3. Where there is a situation of emergency or defense. 4. The obligation to maintain medical confidentiality shall be lifted if the person concerned consents to it unless their declaration is not valid. And 5. Doctors practicing in a public audit, inspection, or expert examination service shall be exempt from the obligation of medical confidentiality only concerning their principles and only as regards to the subject matters of the mandate and the other conditions of its use. The obligation to respect and maintain medical confidentiality does not cease to apply after the death of a patient. Questionnaire. Please proceed to test your acquired knowledge with the following questionnaire. Thank you for participating in Module 3, Lesson 3.